Hello and welcome back to another episode of Legal Talk with Alina. I am your hostess, Alina Gonzalez Dockery, attorney of estate planning and probate here in Florida. And I am thrilled to welcome back one of my favorite guests, Abigale Stolfe. She is the owner, founder of Jersey Coast Family Law, and she has been beyond impressive every time we've had these opportunities to speak. I mean, not only is she been awarded as the marquee who's who of attorneys in 2020, Premier Lawyers Lifetime Achievement Award, and an amazing appellate attorney as well. Miss Stolfe, or Abby, as I've grown to get to know her, really has this amazing service-oriented, client-oriented practice. And within her practice, she has such a wealth of information. Take out your pens, take out your notepads. This is something that you're definitely going to want to listen to because I always am ready to take notes when I speak to Abby. And Abby, welcome back.
Thank you so much. I do love and enjoy our conversations, and I love coming back here and spending time with you. So thank you for, again, inviting me back.
Well, it's the funny part of it, I guess, is you would think as attorneys, we always talk to other attorneys, we had that fun. But the reality is especially since the pandemic, since 2020, I haven't had that opportunity of cattle calls and just being able to, just shoot the talk about topic, some issues that have been arising. And you and I both do family law as well. And one thing that has occurred from time to time is you have a divorce, you file, you're representing the party, and something very unexpected happens, and opposing party or even your party passes away. How do you deal with that, especially in New Jersey? Because here in Florida, it's kind of still a very iffy subject.
Yeah, so in New Jersey for a while there, a long while, we had what we all called the Carr black hole, Carr being the name of the case that talked about, what do we do in these situations where one of the litigants passes? And where does the case and the asset properly land? Do they stay in matrimonial? Do they go to probate? What if there's no will? What are we doing with this family? Because at the end of the day, again, for me at least, I deal with the family. Right. So I'm curious about what we're doing with the family. So recently, law was passed that eliminated, thankfully, that black hole and gave us some idea of what and how we are supposed to handle these situations. So now we have some better guidance, and we know that an estate will now come in and they take the place of the decedent, and we can still deal with the distribution of assets, not alimony, because alimony, of course, is mandated by federal law and federal rule, so that dies with the parties, but the assets can still be dealt with now. And we recently had some case law come down questioning whether or not that new legislation was retroactive. So what happens, because like I said, it's relatively new. So what happens if a case was already filed before and now the person has passed after the date of this new law? How are we handling that? We now have some guidance that tells us, nope, this new legislation is going to be retroactive. So I unfortunately have experienced in my practice, people have passed, and I now have a new policy where in my conversations, my initial conversations with people, we talk about what are we going to do. My advice to people at this point is when you know you are going to be in a litigation, contested, uncontested, mildly heated, enter and execute a will. Enter and execute a power of attorney, enter and execute a living will, because these are the critical documents that tell the world what you want and how you want what you have to be divided. So even if you should pass during a litigation and your estate has to stand in your shoes, your estate knows what to say, because otherwise it's just a big argument between maybe your children and their other parent, which is uncomfortable.
Well, and for our audience, and more particularly your audience, really. So let's talk about a little bit of this black hole. So what was the car black hole prior to this legislation? How did cases get dealt with if one of the parties in divorce happens to die?
So prior to this new legislation, what we would have to do is we would have to file with the family part, who would then typically send us to the probate part, who would then typically say, hey, wait, you're in family, you have to go back. So we would spend a long time juggling between these two different locations, and if you think about it, if you're not familiar with the courthouse, think about it as I'm going to go to Target to get my groceries versus ShopRite to get my groceries. You're going to two different places to kind of get the same thing, right? I need bread, I'm going to these two places. So we would have to bounce a lot. And in so doing, you could get conflicting information. The probate court might say, well, no, we have a will, and the will says that the spouse is going to receive all the assets of the decedent. But the family part says, yeah, but they were in the middle of a divorce, and the spouse's heirs, otherwise, if they were intestate, would be entitled to all these assets. We had a case recently where a woman died without children. She had not updated her will, and she had chosen not to do that. And her will provided for her husband to receive her assets. They're in the middle of a divorce litigation. Nothing is signed. They're still arguing. Her parents came in when she passed and said, well, now we are the natural heirs to her estate because she was our daughter with no children of her own. The husband said, no, 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 there's a will. I get everything. It's all mine. So that one bounced for quite a while because the probate court versus the family court, that was the black hole, right? That was the big question. Where does this thing land? And when you're in the middle of a divorce, does that person who you're seeking to separate from now get all your assets? And I know that there have been cases like that out of Florida as well. And this is not an uncommon event.
No, and even and it's been some time, I guess I should say. I'm very happy for that. But even in that case, we did a suggestion of death, voluntarily dismissed the action, and that spouse took everything. Because under Florida law, when a couple receives a final dissolution of marriage, a final judgment of divorce, that will sever any wills. It basically nullifies any bequeath to a spouse based on the fact that they will be deemed as predeceasing the spouse. But during the event of a divorce where there is still an intact marriage by law, that's where it gets a little muddied. So that's why I'm very much interested in this because for us down here, it is a question, especially when you're dealing more with like the golden divorce, where you have people who are older and long-term marriages and getting divorced for whatever reason. It's, well, what does the court do? Do we say, well, wait a minute, does the divorce action actually then nullify any intestate or testamentary gifts or not? And that's why I'm especially excited about this topic, because it does go into the estate planning side. So obviously now it's definitely an interesting initial consultation or consultation with a prospective client going, not only are we going to discuss your divorce, but hey, have you considered writing a will? I mean,
Exactly.
that go. I need to take notes on this.
Right. Death of your marriage, death of you. Let's talk about death all at one time.
Exactly. I mean, we're not trying to be totally flippant about a divorce. Is a very emotional aspect, but these are serious issues that are starting to come up more and more. Some people think that divorces are among like maybe younger set people healthy, but it's not. You're seeing more of that golden divorce, or even, boomers or older Gen Xers that may have some health conditions or unknown. So when is a good time to get a will when you're beginning the divorce process?
If you are divorcing, the best time to do your will is right there in the beginning. When you are doing your initial round of information, when you're giving counsel all of your background and all of your financials, and all those pieces that are very personal to you and your family, that's the time to discuss the will. Now, it's important in New Jersey, maybe not in every jurisdiction, but certainly in New Jersey, whatever insurance you had, so if you had life insurance naming your spouse, that would have to stay intact. So that's also why this becomes very important, because the insurance might be a bulk of someone's estate and someone's estate plan. So it's really important that we secure whatever's non-insurance to go to the remaining heirs through that will.
That is, I mean, it really touched points on so much, because even like, let's say, and I'm sure your practice deals with a lot of blended families. For those of us who know this rerun, the Brady Bunch, family where you have children from previous relationships, you're starting a new family, you may have children, biological children, stepchildren, and it does complicate, but also make interesting what could happen in not necessarily even just a divorce, but how a parent will deal with those children. And we're going to take a quick commercial break. We're going to come back and talk about that very same subject. We're keeping on point. So tune back in so we can get further educated by Abby Stolfe. Thank you.